Hi there. Short video today on some of the challenges and unique nature of planning for blended families. So, if you are in a blended family and you are curious about some of the unique considerations, this is the video for you. Blended family are spouses who have children from outside of that relationship. So sometimes they come in all various forms, but when I say blended family, that's primarily what I'm discussing. And there are a couple of issues. There are many issues that are unique to blended families in estate planning, but there are two that I'm going to focus on today. One of them is obvious, and one of them is probably much less obvious. The take-home message is going to be if you are in a blended family, that your planning needs from an estate planning perspective are probably more urgent, more important than even the typical family situation that we think about that is not a blended family. So I would encourage you, at the end of the day, I'm going to encourage you to seek professional advice to make sure that you have a good, solid plan in place. But I want you to know what the issues are. And so these two issues that I reference are, one, again, the first one is the obvious one, and that is that if you are in a marriage where there are children that are of one spouse and children that are of the other spouse, or children of one spouse and the other spouse doesn't have children, then the obvious concern is that when one spouse passes, if you use some of the very most basic traditional estate planning methods like a will, everything to the surviving spouse, beneficiary designations with designating that the asset, the account, the house, the other property will become fully the surviving spouse's property upon the death of the first spouse, it's probably not going to achieve the deceased spouse's objective, which in most cases would be that eventually the wealth that they brought into the marriage and even half of the wealth that they accumulated during the marriage is going to make it to their own children, and that the surviving spouse's children obviously will receive the surviving spouse's share of that. There are ways to accomplish that, and I'll just leave it at that as estate planners, we certainly have ways of very securely accomplishing that objective. But you're probably not going to be able to arrive at that on your own if you're trying to do like a basic will, a download from online or something like that. It's probably not going to work out in the end the way you think it will. So that's the first issue, and I think that one is fairly obvious. I think in our practice, most blended families, when they come in, and we have many clients that are part of a blended family, that's the one that they're thinking about primarily. And we have the tools to achieve the objective. And this is one of the, although we believe everyone needs at least some basic level of estate planning, people in blended families are among the classes of people that really do need to get some professional advice on how to do this, because there are traps for the unwary, and really something that in order to achieve what we think are your basic objectives, you really want to get some good professional advice and assistance. The second issue that technically doesn't come up only in blended families, it can come up in any family where there's a marriage, but it's worthy of talking about in the blended family conversation, which is, when you have an estate plan, have you accounted for what might happen if after the death of the first spouse, the surviving spouse later becomes remarried? Now, there's an issue many people aren't aware of, and Maryland is one of a number of states that have laws that are structured this way, which is that you can't you unilaterally disinherit your spouse. What that means is that if you're married to someone, if you don't have a prenuptial agreement or a postnuptial agreement waiving these rights, the surviving spouse automatically has a right to take a portion of the deceased spouse's estate, which includes property passing under a will, as well as property passing under a revocable living trust, or a life insurance benefits, or joint account ownership, or virtually any other, by any other means. If it passes from a person who is deceased, the surviving spouse has rights, unless those rights have been waived. So what that means is that if you pass away before your spouse and your spouse becomes remarried, it further complicates the later transition of wealth from your surviving spouse to your children, or to their children, or to the children that you share together, unless you plan for that. And so there's almost no issue or challenge that we can think about in estate planning that we can't plan for and address ahead of time. But unfortunately, many people don't recognize them. If they do recognize them, they don't recognize the need to plan ahead. And so that is one of those issues that's Again, not unique to blended families, but it's something that probably comes up more often with blended families as we're talking this through, depending on ages, etc. So always something to consider. So if you are in a blended family, you're contemplating marriage that would result in you being in a blended family, or you're concerned about what those challenges are and how they might be addressed through good, proper estate planning, feel free to give us a call. Our number is 410-570-1671. We'd be more than happy to work with you and get the solutions that you want to plan ahead to make sure that the goals that you have for your own children, etc., can be met in the future. Thank you for joining us.